Ever wondered what really happens inside the correctional system? Beyond the headlines.
Yeah.
What are the actual rules, the principles that govern the lives of people who are detained?
It's a huge question, isn't it?
It really is. Today, we're doing a deep dive into a really critical piece of legislation,
Yeah.
the Correctional Services Act 111 of 1998. And this act, it's not just some dry set of regulations. It's basically the blueprint for South Africa's entire approach to incarceration and, importantly, rehabilitation.
That's exactly right. And our mission today really is to unpack this act, this consolidated version, in a way that's clear and hopefully engaging for you, whether you're, just curious, maybe a law student, or honestly, anyone who wants to be better informed.
Right. Yeah.
We'll look at its core purpose, we'll dig into the key provisions, give some legal context, talk about the practical side of things, and really highlight why it matters in the real world.
And crucially, we're basing this discussion directly on the authoritative text of the act itself.
Absolutely, including all the updates, the amendments over the years. So you're getting the most current, comprehensive picture we can offer.
Okay, so let's unpack this then. At its heart, what is this act, Act 111 of 1998, actually trying to achieve? What are the sort of big picture goals?
Well, fundamentally, the act provides for a comprehensive correctional system. It sets up and controls the Department of Correctional Services, outlines what they do.
Okay.
But here's the absolute key part, I think. Its main purpose isn't just locking people up. It specifically aims to ensure, and this is a direct quote, the custody of all inmates under conditions of human dignity.
Human dignity, that sounds foundational.
It is. It's not just a nice phrase they threw in. It's a core, non-negotiable principle that's supposed to guide literally everything else the system does.
So it's way more than just containment. It's about how people are held, and that how is rooted in human dignity. What else flows from that?
Exactly. So building on that dignity principle, it then goes on to define the specific rights and, importantly, the obligations of people inside both those already sentenced and those awaiting trial, the unsentenced individuals.
Okay.
It also introduces and regulates this whole concept of community corrections, ways people can serve sentences outside of a correctional center.
Right, like parole or house arrest, that kind of thing.
Precisely. And it establishes independent bodies for oversight, for scrutiny of the department. That's crucial for accountability. Plus, it covers rules for public-private partnership correctional centers and even spells out penalties for specific offenses related to the system.
Wow, okay, that is a lot of ground. And you mentioned that powerful philosophical underpinning human dignity. How does this act fit into let's say, the bigger legal picture in South Africa? It sounds like it must connect to the Constitution, for example.
Oh, absolutely. A really key aspect here is how directly this act plugs into South Africa's foundational legal frameworks. It explicitly states its aim is to change the law to give effect to the Bill of Rights in the 1996 Constitution, specifically regarding prisoners, as they were termed then.
So it's constitutionally driven.
Very much so. And it doesn't stop there. It also explicitly recognizes and incorporates international principles on correctional matters. So it's looking outwards, too, aligning with global human rights standards.
Interesting. So it's not operating in a vacuum. It's deeply embedded in both domestic human rights law and international principles. And I heard you mention the term prisoners. I understand there's been a significant evolution in the language the Act uses over time. That wasn't just about word choice, was it?
You're absolutely right. That was a profound shift. It came mainly through amendments, particularly Act 25 of 2008. You saw terms like prison being replaced with correctional center.
Okay.
And prisoner became inmate or sentenced offender or unsentenced offender.
It sounds much less stark.
Exactly. And it wasn't just cosmetic. It was a very deliberate philosophical move. A signal towards a system more focused on human rights, on rehabilitation, on correction and development, rather than just, punitive measures. It genuinely tried to redefine the approach.
That's a really powerful shift in thinking.
Yeah.
It also sounds like this law isn't just sitting on a shelf somewhere. It's constantly being updated. I see here its last review date was very recent, May 2025, with changes incorporated up to February 2025. It's a living document.
It absolutely is. Think about its journey. It was assented to way back in October 1998, but many sections only kicked in much later, in phases, some as late as mid to late 2004.
Right.
And since then, it's been amended frequently. Various Correctional Services Amendment Acts, even things like the Child Justice Act of 2008 impacted it. These aren't just tiny tweaks. They show this ongoing effort to refine the system, to keep it responsive to changing legal needs, societal views, practical challenges.
And fascinatingly, some amendments are listed as uncommenced, like from the National Health Insurance Act. That's not just legislative trivia, is it?
Not at all.
It means parts of this law are literally still waiting to come into full force. It really underscores how much this framework is constantly adapting, constantly evolving.
Precisely. It's always, or at least theoretically, striving to better meet its complex goals.
Okay, so we've got the foundation, the guiding principles. Let's zoom in now on the actual experience inside. How does that human dignity mandate we talked about translate into, well, the practical day-to-day realities and rights for people inside these correctional facilities?
Right. This is, as they say, where the rubber meets the road. And the Act gets surprisingly specific here to try and ensure that dignity isn't just an abstract idea. Think about the very moment someone enters the system, the admission process.
Okay.
The Act is crystal clear. You cannot be committed without a valid warrant. That's a fundamental protection against just being locked up arbitrarily.
Basic due process.
Absolutely. And from that very first moment, your rights are meant to be front and center. You have to be immediately informed of them. You get access to legal counsel, and this is important, even state-funded if you can't afford it. You have to be given the rules of the facility in a language you understand. If you're illiterate, they need to provide an interpreter. And there's an immediate health checkup, including screening for contagious diseases. It's all about setting a tone of respect and proper procedure right from minute one.
Wow, okay. So transparency, rights, health checks, all mandated right at the start. What about the physical space, where people actually live inside?
Good question. For accommodation, the regulations actually go into quite a bit of detail. They specify minimum floor space, proper lighting, ventilation, sanitation in cells. It's all aimed at making sure the conditions themselves uphold human dignity.
Not just warehousing people.
Hopefully not. And importantly, there are strict rules about separating different groups of inmates. Sentenced from unsentenced, males from females, and crucially, children must be kept separate from adults. This is about preventing vulnerability and ensuring the environment is appropriate for each group.
Makes sense. And what about basic survival needs? Food, hygiene? We often hear grim stories about prison food, for example.
Well, the Act tries to address that directly. For nutrition, it mandates an adequate diet, sufficient for good health. And it specifically mentions giving special consideration for the dietary needs of children, pregnant women, and those with specific religious or cultural requirements. Clean drinking water must always be available, too.
And hygiene.
For hygiene, the department is required to provide inmates with the necessary means, think soap, clean clothes, things like that, to maintain personal cleanliness. And inmates are, in turn, required to keep themselves clean.
Okay. And healthcare. That must be a massive concern for anyone in custody.
A huge one. The Act states inmates have the right to adequate healthcare services based on primary healthcare. They can even choose to be visited and treated by their own doctor, although they'd have to pay for that themselves.
Right.
But here's something quite remarkable, I think. No inmate can be forced to undergo medical treatment without giving informed consent.
Really? Even in detention?
Yes, unless refusing treatment poses a direct, immediate threat to the health of other people in the facility. And informed consent is generally required for any surgery, too. Think about that safeguard. It's a profound protection of bodily autonomy, even within the walls of a correctional center.
That is a strong protection. What about keeping connections with the outside world? That seems vital for eventual reintegration.
Absolutely critical. The Act actually encourages contact with the community. Inmates are entitled to receive visits. A minimum standard is set at 1 hour per month from people like spouses, next of kin, religious counselors, even their medical practitioners. Foreign nationals have the right to communicate with their diplomatic representatives, and the department is obligated to notify the next of kin when someone is admitted or transferred. This notification is mandatory if the inmate is a child.
Good to know. And what about support inside for rehabilitation and development, since that's a core aim?
Right. The department is tasked with providing correction, development, and care programs and services. They also have to inform inmates about services available from other organizations.
So connecting them to resources.
Yes. And there are specific measures mentioned to accommodate inmates with disabilities and to create gender-sensitive environments. For children and mothers, the provisions are quite detailed. Children must receive compulsory education, access to social workers, religious care, recreation, psychological services. Female inmates can keep their children with them up to the age of 2, sometimes longer, if it's clearly in the child's best interest, and the department is responsible for the child's care during that time.
That's a remarkably thorough list of rights and provisions.
Yeah.
How does an inmate actually raise their voice if something's wrong, if they feel their rights are being ignored?
There's a clear, multi-step process for complaints and requests. The Act says inmates must have a daily opportunity to make complaints or requests directly to the head of the correctional center.
Daily.
Daily. And these must be recorded and addressed promptly. If the inmate isn't satisfied with the response, or if there isn't one, they can escalate the complaint. First to the National Commissioner, and then ultimately to the independent correctional center visitor, that independent oversight body we mentioned. So there are multiple levels of recourse built in.
Okay, so that covers the right side of the equation.
Yeah.
But obviously a correctional facility needs security, it needs order. How does the Act handle that crucial balancing act, ensuring dignity while maintaining control?
That's the million-dollar question, isn't it? And the Act tries to navigate it carefully. It states very clearly that discipline must be maintained with firmness, but in no greater measure than is necessary.
Firm but fair, essentially.
That's the idea. It defines various disciplinary infringements, things like dishonesty, assault, gang activity, possessing unauthorized items. There are procedures for disciplinary hearings and specified penalties, but always framed within that overarching human dignity principle. You can't just impose any punishment.
What about more serious measures, like segregation? That often sounds very punitive.
And here's where the Act makes a really important distinction. Segregation, under this law, is not meant to be a form of punishment.
Oh, how so?
It's only permissible under very strict, limited circumstances. For example, if the inmate requests it in writing, perhaps for their own safety, or on medical grounds, or if they're being violent, pose a serious escape risk, or if it's deemed necessary in the interests of justice, maybe during an investigation.
So specific reasons, not just arbitrary isolation.
Exactly. And it comes with tight time limits. Normally a maximum of 7 days. It can be extended up to 30 days, but only with approval from the National Commissioner or based on medical advice. And crucially, any segregation requires immediate reporting to both the National Commissioner and the inspecting judge. Plus, the segregated inmate must be visited daily and have their health assessed. The emphasis is meant to be on safety and security, not punitive isolation.
Okay, that's a critical distinction. What about mechanical restraints? Chains, handcuffs, things like that. Are they ever used for punishment?
No, the Act is explicit.
Yeah.
Absolutely not. Similar to segregation, mechanical restraints devices that limit physical movement are never to be ordered as punishment.
So when can they be used?
Only when strictly necessary for immediate safety, preventing self-harm, harm to others, serious damage to property, or preventing an escape while being transferred. They can only be used for specific, limited periods, and again, their use requires immediate reporting to both the National Commissioner and the inspecting judge. There's even a rule that inmates generally can't be brought to court wearing restraints unless the court itself specifically authorizes it. Another key legal safeguard.
What about the use of physical force by officials? That's obviously a very sensitive area.
Extremely sensitive. The use of force is authorized only as a last resort. The standard is the minimum degree of force proportionate to the objective. Meaning only use the amount of force needed to achieve a specific legitimate aim, like self-defense, preventing a likely escape, or protecting property from imminent danger. It generally requires prior authorization unless the situation is so urgent that an official reasonably believes authorization would be granted if there were time to ask.
And accountability afterwards.
Absolutely critical. Any use of force, any use mandates an immediate medical examination for the inmate involved. And, like segregation and restraints, it must be reported immediately to the inspecting judge. This is about ensuring accountability and checking that force wasn't used excessively or improperly.
Okay. And things like non-lethal devices, tear gas, or even firearms. Are there strict controls there too?
Definitely. Non-lethal incapacitating devices and firearms can only be issued to officials who are properly trained to use them. And they can only be used under very specific, limited circumstances. For instance, if an inmate refuses to drop a dangerous weapon after being ordered to, or as a last resort to prevent an escape when other methods have failed or are likely to fail.
Specific examples.
Well, for tear gas, the Act specifically says it cannot be fired directly at a person or into a confined space occupied by inmates unless there's absolutely no alternative. And again, strict reporting procedures are mandatory for any use of these devices or firearms. Accountability is woven throughout these high-risk areas.
Let's shift gears slightly now, towards the end goal for many inmates. The Act states a core objective of sentences is enabling offenders to lead a socially responsible and crime-free life in the future. That sounds like a major departure from just pure punishment, doesn't it?
It really is. It speaks volumes about the intended transformative goal of the act, moving beyond mere containment. And this whole process ideally starts very early on with a comprehensive assessment.
Assessment. What does that involve?
It happens as soon as possible after admission for a sentenced offender, and it's incredibly thorough. It covers their security classification, obviously, but also their health needs, education level, social background, psychological state, religious needs, any specific development needs they have, their potential for work, suitable location within the system, needs for reintegration planning, possibilities for restorative justice. And critically, it includes assessing their vulnerability to sexual violence within the facility. It's meant to be a holistic look at the individual.
Wow, that's detailed. So it's a deep dive into the person, which then leads to what? Plan.
Exactly that. For offenders serving longer sentences, generally over 24 months, a body called the Case Management Committee uses that assessment to compile a tailored correctional sentence plan.
Tailored how?
It directly addresses the specific risks and needs identified in the assessment. The goal is to correct offending behavior, yes, but also to develop skills, address personal issues, basically prepare them for eventual reintegration into society. And the inmate has to be informed about their plan and has the right to make representations to have input.
And what about work and development during the sentence?
The Act is clear that any labor provided should aim at imparting skills useful for employment after release. It explicitly states that labor must never be assigned as a form of punishment.
Okay, skills, not punishment.
Right. And the department is also mandated to provide a full range of educational, training, social, and psychological services. Participation in literacy programs is mandatory for illiterate inmates, and education is compulsory for children. The Act also specifically mentions that programs should be responsive to the special needs of women offenders.
This raises an important point, though. What about people who haven't actually been convicted yet? Individuals awaiting trial or sentence, the remand detainees. Their situation is legally quite different, isn't it? How does the Act handle them?
That's a crucial distinction, and the Act recognizes it. For remand detainees, the principle is that any restrictions placed on them should be limited only to what's absolutely necessary for security and maintaining order within the facility. The aim, explicitly stated, is to allow them access to amenities they would normally have if they were outside as much as possible.
So, presumption of innocence reflected in their treatment.
That's the ideal. For example, they wear a prescribed uniform, but it has to be one that visually distinguishes them from already sentenced offenders, and they cannot be forced to wear that uniform when appearing in court. If they don't have suitable clothes of their own for court, the state has to provide them. Their status as unconvicted individuals is meant to be protected.
What about vulnerable groups among remand detainees, say pregnant women or elderly people or those with disabilities?
Yes, the Act makes specific humane provisions for them, too. Pregnant women should be housed in special units and receive an adequate diet. Individuals with disabilities might get separate detention arrangements and additional health care. Aged detainees could also be housed separately and have dietary variations. And those suspected of having mental illness should be under observation, get adequate health care, and social or psychological support.
That's comprehensive. Is there anything about the length of time someone can be held on remand? That's often a big issue.
A very big issue. And here the Act introduces a critical legal safeguard. It sets what it calls a maximum incarceration period for remand detainees, 2 years from their initial admission without their case receiving court attention.
2 years. What happens then?
The head of the remand detention facility has a positive duty. They must refer the detainee's case back to the court for review every 6 months before that 2-year mark. And if detention continues beyond 2 years, the case must be referred back to court annually for review, specifically for the court to determine whether continued detention is justified or if the person should be released.
So, a mechanism to prevent people falling through the cracks indefinitely.
Exactly. And there are also provisions allowing for terminally ill or severely incapacitated remand detainees to be referred to court at any time for consideration of release on medical grounds.
Okay, this brings us logically to the ultimate goal for many: pathways back to the community. How does the Act facilitate release and reintegration? You mentioned community corrections earlier.
Right. The objectives of community corrections are laid out quite clearly. It's about allowing certain offenders to serve their sentences, or parts of them, outside of a correctional center, hopefully enabling them to lead crime-free lives, facilitating their rehabilitation, and ultimately ensuring their full integration back into society.
And how does that work in practice?
Yeah.
What kind of conditions can be imposed?
There's a whole range. It could be house detention, requiring them to stay at a fixed address. It could involve community service, or requirements like seeking employment, paying compensation to victims, maybe participating in specific treatment programs. The Hay Act even mentions victim offender mediation as a possibility.
Interesting.
Other conditions could include contributing towards the cost of community corrections, refraining from alcohol or illegal drugs, and monitoring is key that can include electronic monitoring devices. But here's a crucial element. The person being placed under community corrections must agree to the conditions imposed. It fosters a sense of participation in their own journey.
So it's not just imposed top-down. Who actually makes these critical decisions about placing someone on community corrections or parole?
That responsibility falls mainly to the parole boards. Specifically, there are Correctional Supervision and Parole Boards, often called CSPs, established for different management areas. There's also a National Correctional Supervision and Parole Review Board.
And what do they do?
The local CSPs make the decisions about placing most offenders on correctional supervision, day parole, or full parole. They also make recommendations in specific cases, for instance. For offenders declared dangerous criminals, the recommendation goes to the court. For offenders serving life sentences, the recommendation goes to the Minister of Justice and Correctional Services.
Okay. And what about eligibility? When can someone actually be considered for parole? Does a life sentence, for example, really mean life without parole?
There are specific parole eligibility periods set out in the Act and related legislation. For instance, under the current rule specifically for offenses committed after the relevant chapters commenced around October 2004, and considering a 2021 amendment effective Feb 2025, an offender serving a life sentence generally may not be placed on day parole or full parole until they have served at least 25 years of their sentence.
25 years minimum for life.
Yes. And for someone declared a habitual criminal, they are typically detained for 15 years, but can be considered for parole after serving 7 years. So, while sentences like life are indeed very long, the system does build in pathways for eventual review and potential release.
Is there also a possibility for release on medical grounds, separate from standard parole?
Yes, there is. Medical parole is a distinct and important provision. It allows for an offender to be considered for release if they are suffering from a terminal disease or if they are rendered severely physically incapacitated by an illness or injury.
What are the criteria?
The key conditions are the severity of the illness or incapacitation, an assessment that the risk of the person reoffending is low, and crucially, that appropriate arrangements for their care and treatment in the community have been made. There is a medical advisory board involved to provide independent reports, ensuring these decisions are medically sound and ethically considered.
So compassionate release in specific circumstances. Are there any other special release mechanisms?
The Act does grant some special powers. For instance, the National Commissioner can grant special remission of sentence for highly meritorious service by an inmate. There are also provisions for special measures for reduction of correctional center population, which could involve early release, but only if overpopulation becomes so severe that it threatens conditions of human dignity and safety. And importantly, the president retains the constitutional powers to authorize placement on correctional supervision or parole at any time, and also the power to pardon or reprieve offenders.
It's clear that accountability seems to be a thread running through this whole act. What about independent oversight? How does the act ensure that the system is actually held accountable? It sounds like there are real watchdogs built in.
This is a truly vital part of the structure, especially when you connect it back to that core principle of human dignity and constitutional rights. The Act establishes some robust, independent oversight mechanisms. First and foremost, there's the Judicial Inspectorate for Correctional Services.
Judicial Inspector, what's that?
It's an independent office, deliberately separate from the department. It's headed by an inspecting judge, who must be either a serving high court judge or a retired judge.
And their job?
Their core mandate is to inspect correctional centers across the country, to report on how inmates are treated and the conditions they live in, and specifically to investigate allegations of corrupt or dishonest practices within the system. The inspecting judge can receive complaints from inmates, officials, the public, anyone really. They produce an annual report which goes to the president and the minister, and crucially, that report must be tabled in Parliament for public scrutiny. It's designed to be a powerful, independent voice holding the system to account.
That sounds significant. And beyond that high-level judicial oversight, are there mechanisms for addressing complaints more directly on the ground?
Yes, absolutely. That's where the Independent Correctional Center Visitors, or ICCVs, come in. These are individuals appointed for each specific correctional center. Their primary role is to deal directly with inmate complaints at the facility level.
How do they do that?
They conduct regular visits to the center, they have the right to interview inmates privately, they record any complaints made to them, and they try to resolve issues internally with the head of the center first. If that doesn't work, or if it's a serious matter, they can refer the complaint upwards, either to a regional visitors committee or directly to the inspecting judge. It provides a direct, localized, and independent channel for grievances, trying to ensure nothing falls through the cracks.
So external watchdogs are crucial. What about internal checks and balances? How does the Department of Correctional Services monitor itself to ensure compliance and accountability?
The Act mandates strong internal compliance functions, too. The National Commissioner has a specific responsibility for compliance monitoring. This involves things like internal auditing, performance auditing, conducting inspections of facilities and operations, and carrying out internal investigations. The goal is to ensure the department is running effectively and adhering to the principles and rules laid out in the Act.
Are there specific units for that?
Yes, the department has, for example, a departmental investigation unit, which focuses on tackling issues like theft, fraud, and corruption within the department itself. There's also a code enforcement unit responsible for handling disciplinary proceedings against officials who breach the rules. So it's meant to be a comprehensive internal system alongside the external oversight.
And I remember you mentioning something earlier about a relatively recent change regarding mandatory reporting. That sounded quite significant for transparency.
Absolutely. This was introduced by the 2023 amendment, which came into effect on December 1st, 2024. It establishes specific mandatory reporting obligations of the department to the inspecting judge.
What does that mean in practice?
It means the department must provide immediate notification, followed by a detailed written report within 24 hours, directly to the inspecting judge for a whole list of serious incidents,
Gotcha.
such as any death of an inmate, regardless of cause, any instance of segregation, especially extended segregation, any use of mechanical restraints or physical force, any assault, whether it's an inmate assaulted by an official or an official assaulted by an inmate. Critically, it includes any act that could constitute torture or cruel, inhuman, or degrading treatment or punishment. Also, any reported sexual violations, things like hunger strikes, attempted suicides, escapes, and even matters relating to suspected dishonest practices or corrupt activities discovered internally.
Wow. That list covers almost every major potential area of abuse or critical incident.
Exactly. This provision marks a massive step towards enhanced transparency and accountability. It means these serious events cannot legally be kept hidden from independent oversight. They have to be reported promptly.
That really does sound like a profound commitment to embedding human rights monitoring into the daily operations. One last area on structure. How does the Act handle the involvement of private companies in running prisons? Public-private partnerships or PPPs?
Right, the Act does allow for this. Under Chapter 14, the minister can enter into contracts with private parties. These contracts can cover the design, construction, financing, and importantly, the operation of what are termed public-private partnership correctional centers. These contracts can run for a long time, up to 25 years.
Are there controls? Concerns are often raised about private prisons cutting corners.
Yes, and the Act tries to address this with very strict duties and restrictions placed on these private contractors. For instance, a private contractor or their employees cannot take disciplinary action against offenders. That power remains with department officials. They cannot be involved in determining the sentence computation. They cannot make decisions about parole or release.
So core state functions remain with the state.
Precisely. And to ensure compliance, the National Commissioner appoints a departmental official, called a controller, specifically to monitor the operations of each privately run facility on a day-to-day basis. The aim is to ensure they adhere strictly to the Act's standards and that the profit motive doesn't compromise inmate rights, safety, or the principles of the Act.
And finally, just briefly, what about enforcement powers for officials and specific offenses related to the system?
Correctional officials are granted certain powers necessary for their duties, powers of arrest, entry, search, and seizure, but these are specifically linked to achieving the objectives of the Act, like preventing escapes or finding contraband. The Act also defines a range of specific offenses within the system.
Examples.
Things like interfering with a correctional official performing their duty, aiding an escape, helping an inmate get unauthorized items, unauthorized removal of an inmate from custody, absconding if you're under community corrections, even providing false identification details if you're a remand detainee. These provisions are there to protect the integrity and security of the correctional environment itself.
Okay, what a comprehensive journey that was. We've really traveled through the Correctional Services Act 111 of 1998. We explored its foundational commitment to human dignity, looked at the really complex day-to-day realities of managing facilities and the people within them, traced the pathways for rehabilitation and release, and examined those multi-layered oversight mechanisms designed to ensure accountability and transparency.
Indeed. And I think if there's one key takeaway, it's that this act is, well, it's intended to be a dynamic and incredible comprehensive legal framework. It's constantly trying to balance that difficult equation, the need for public safety on one hand, with a really profound emphasis on human rights, rehabilitation, and the potential for reintegration on the other, for all individuals who find themselves within the correctional system.
Right.
And the fact that it keeps evolving, keeps being amended, that really underscores society's ongoing and often difficult conversation about justice, about punishment, and about what rehabilitation truly means.
So, thinking about all this, what does it mean for you, our listener? Maybe consider how the intricate details of a law like this, the specific rights, the oversight rules, the language used, how they don't just shape the lives of people inside the system, but also reflect the wider values, the aspirations, maybe even the contradictions, of a democratic society trying to grapple with crime and punishment.
Hmm.
How does knowing about these specific rights, these complaint mechanisms, these oversight bodies, empower you perhaps to engage more critically in discussions about criminal justice and human rights in your own community or country? What further questions does this deep dive spark for you about the future of correctional services, not just in South Africa, but maybe globally? Something to think about.